has the Splice situation been resolved? So your videos are still up; they haven't been taken down. Has the strike been removed?
Down. It was taken down, and here's obviously the strike is no good. The video being down is no good. But at that point, I had a decision to make, which is my account is at risk.
I know a lot of people leave comments saying this deserves more views. Look, I'm not going to argue with you. I just appreciate the support. Some of you are leaving super thanks, which really helps me. But you can help me in free ways too. If you just subscribe, if you like the video, if you leave a comment, all of that helps me quite a bit. And if you really want to be super supportive, then share the video as well. That helps, I think, more than anything. I have Miss Crystal, aka the top music attorney, here with me. Thank you so much for being present. I've gotten a lot of comments since I covered one of your videos, the one having to do with Splice terms of service. And since then, some interesting developments have arisen, and I've gotten comments regarding those developments. Actually, I had no idea that there was even a legal battle, if we can use such dramatic language, that was ongoing. But I got some comments from people saying, well, her video was removed. What actually happened?
Oh man, yeah. So there's different things. My first video that I did on Splice, and anyone who's watching this who's new is not familiar, Splice is really a great platform if you need samples, you need loops, you need all kinds of great stuff for your music creation process. So I do terms of service review, so I'm the music lawyer, and I go through and I look at contracts very carefully because they're so long. You go through these things, they're like 20, 30, 40 pages long. So my goal is just I've done this so much, I know what they say, and I go through and just try to explain it. And to point out some stuff that like people just maybe not, maybe they don't know is there, so just whatever. So that's why these videos are called like exposed. So DistroKid exposed, Splice exposed, because I'm exposing what the contract says. So I did a video on their terms of service, and I ended up getting a cease and desist email the following day from their legal department. And, the legal department was just like, look, you're saying stuff, and we don't agree with your interpretation. And I just kind of challenged and been like, look, I'm just seeing inconsistencies in the drafting, which doesn't mean that, like, a company's trying to be sneaky or anything. It just might be that the person who drafted the contract missed some stuff. But I go, nonetheless, it's really important for music producers and creators that when you use these samples that you are, like, free and clear to release the music, to sell it, to distribute it, to do all the stuff you gotta do. I'm like, I think that's the intention, so if it doesn't say that, you guys should know. So
well, anyway, you concluded that it was, in your defense, you didn't, I watched the video, and you didn't conclude that the commercial usage license was unclear or anything to that effect.
Yeah, because I pointed this out. I go, it says that the rights contained in the agreement are non-transferable, which usually means, so if DJ Payne 1 is downloading the samples and then he's like going to collab with Crystal, and Crystal comes in and is like, hey, I'm just going to copy your file and take it and put it on my computer. That's not transferable. That makes sense. But where I just was kind of pushing a little bit, I go, I'm looking at this through the standpoint of DJ Payne 1 makes a song that he now wants to sell. When you sell a song that has a sample in it, you have to give the license that goes with it to be like, it's okay for this thing to be in your song that you now own. I go, the non-transferability does not clearly say that. They say you can sub-license, release, you can remix. It does not say you can sell. So I just pointed that out. But I go, it does say you can use it for commercial purposes, though. There's no question there.
I see what you're saying. So you were more or less challenging Splice to just put what is implied and what we obviously think they intend, because clearly you can use a Splice sample in a beat and then sell that beat because everyone's doing it, and there's never been any sort of legal case against that, right? And you just wanted to make it clearer for the end user.
Yeah, and when they reached out to me, even though it was technically a cease and desist, and they're like, you should know better as an attorney, all this stuff, I emailed them back, and I'm like, wow, thank you for reaching out, like, to let me know, and if you want to clarify this stuff, let's jump on a call, because actually I have a show coming up, so you guys can give me updates, and then we'll go through it. So on the call, it was a little bit challenging, because there was two attorneys, and they were conflicting with each other on what some of this stuff is, and I'm like, like this thing with the certified license that you get as a producer. I actually wasn't even aware of this. And my producer and I use their platform. And we read about it in the terms of service. And so I was talking to them about this license, and they were explaining, it doesn't matter if you terminate your account, you can come back anytime, and we will help you to get this license. I'm like, wow, that's really good to know. So I'm going to share that with my audience. It doesn't say this in the agreement. And in fact, it says in the agreement that once you terminate, your account gets deleted, your stacks, like all your stuff is gone. And so on the call, there was a little bit of confliction between the attorney. So I just go, look, I'm making notes. I'm going to do an update. So I did the update, and I don't pull punches on my channel, which is like, hey, I got a cease and desist email. And I went through the email and I talked about it, and they didn't like that. And at the end of the show, I also showed this certified license for purposes of being like, hey, I've never seen this before. This is what it looks like. And like, you guys save this. This is how it works. So it was meant to like educate the audience in case someone wasn't aware of this. And anyway, so then the day after that live stream, I got notice that they had filed a copyright strike on my video. And 3 strikes, you're out, your channel gets deleted. It's a bad thing because it's a step up in severity from just a claim of being like, hey, I think you used something in your video, I'm going to monetize your video. It's way more severe. But anyway, so what they claimed and, what they had filed with YouTube was that I showed this certified license. And so when I was like emailing with the team, I'm like, hey, you guys have been in touch with me. No one reached out. You just filed this. But, I just explained to him, I'm like, fair use. You're allowed to, like on your channel, you do a lot of educational stuff. So if you ever react to one of my videos, I can't say anything about that, even though you're using my copyrighted content because you are using it to criticize, educate, comment. And that's how it works with this document. So they're like, that we showed our certified license. And in the email that I got back, they just went, our problem is that you are showing a proprietary document. We don't want people to see what this looks like so that fakers can come and make fake versions. I go, wow, that's like a really good argument. Except, not only is there like a plethora of other people who have uploaded videos that they don't do anything about on the internet, so it seemed very personal. On the Splice YouTube channel, they have a video that goes, here's a license, this is what it looks like. You know what I'm saying? So I'm like, it seems like you didn't do it for those reasons that you're saying.
That's interesting. It sounds like there may be some miscommunication internally at Splice, which, is a shame because ultimately Splice is a great platform. I use it all the time. I know virtually every producer I collaborate with uses Splice all the time. No one that I know has ever had a problem with it other than external factors that affect Splice. So I'm glad you brought up a couple things that I want to pick up on. One was fair use, because I feel like fair use is one of the most grossly misunderstood and also misrepresented legal doctrines / laws, especially in the producer community. And also you talked about the certified licenses that Splice allows users to download. And that is in response, I believe, correct me if I'm wrong, that's in response to all of the content ID problems that just plague the producer community. That's Splice's way of helping producers out, because a lot of us, not even with Splice, just in general, we're getting copyright strikes like crazy. If the system just flags, because a lot of it's based on AI and it's automated, and it just, as we know, AI is problematic, so it will get it wrong. I know people who will create a beat using their mouth or something on a live stream, and they end up getting struck. They're like, what? Huh? The system is crazy. Or, we use a royalty-free sound, and then someone else uses the royalty-free sound, but they monetize via Content ID. All of a sudden, their hands in our pockets. So we don't know, as producers, how to fight these legal battles. And so having something like a certified license, and I wish every content provider did something like that, that's helpful. So I want to ask, I given the common scenario where, I make a beat with a Splice sample, someone else makes a beat with the same sample, but they decide to be a jerk and run it through a Content ID system. Content ID doesn't account for royalty-free usage. It doesn't account for shared ownership. It's very archaic in terms of single owner, like a label owns this, period. And the new music industry is full of collaboration. Even the old music industry is full of collaboration. You know what I mean? Like there are very few scenarios in which a single person owns every copyright to a recorded piece of music. So what do we do? And then, as a lawyer, and I apologize for not giving you a proper introduction. You're an entertainment lawyer, but you also litigate.
You got it, yeah. So, and I'm full time. You know what I'm saying? I'm not like a lawyer turned YouTuber yet. That'd be great. But I have a law firm. I've been doing this for over 10 years. I do litigation, but as an entertainment and music attorney, the goal is to help people with their businesses. You know what I'm saying? To just help them to set up the business, grow the business, make money. But then stuff happens, and sometimes you do need to actually file lawsuits and enforce. I mean, I even talked about this on my video with Splice. I'm like, or regarding Splice, I just go, these situations come up where someone's filing strikes on your channel, like fake strikes that are not based on actual copyright claims. We have to go and file what's called an injunction. It's like a lawsuit, but to get someone to stop doing something, because it's going to, destroy all your hard work. But back to your where you're going with that, the content ID issue. It's funny because some producers utilize it to track illegal, right, or unauthorized, I should say, uses, right? So they'll, do that so they can get notifications when someone uploads something, and then they go to the person like, hey, you owe me money. So it's being, utilized in that way. And funny enough, on my call with Splice, the legal team was telling me that Splice registers the majority of their sounds on Content ID. And I was like, well, I'm not sure. I'm not sure why you would do that, because that's going to now create problems for all your users. So I don't know if someone maybe misspoke, just practically. But what you're talking about is that usually it's like the first to the platform. And now you're claiming, you're like, this is my song. And so now the algorithm's going to get confused and flag other people's songs. So look, what they're trying to do with the certified license is to alleviate that problem. So, YouTube, your music distributor, Spotify, whatever it is, you can come back in and be like, hey, here's my thing, release the claim. And it sucks that people have to go through all those loops.
Yeah, it does. It takes up a lot of time, and especially if you have thousands of beats out, you might be getting a claim every single day or multiple claims every single day. If people are leasing your beats non-exclusively, they're running it through the Content ID system. People aren't reading the terms, and I think that's why your particular videos where you expose the TOS of a lot of these, either distributors, Splice, whoever, the fact of the matter is, even for, and I've been in the music business for 15 years, I don't know what the hell some of these terms mean, and legally a lot of them are ambiguous. I think that was the point of your call with Splice, to kind of disambiguate some of those terms and stipulations. And a lot of us in the music business aren't even reading those terms. We're just signing up. We're like, yeah, we agree. And then when something comes up, a problem comes up, whatever, we're kind of scrambling and scratching our heads and wondering, well, where did that come from? And maybe it's in the terms, maybe it's not, but who knows? And I think Content ID, on the producer side and on Splice's side, they don't allow people to do that. The terms forbid that, and people turn around and do it anyway. And I think a lot of it is them just not knowing. They're not reading the terms. If they are reading them, they're skimming them. If they are not skimming them, then they're not understanding it. Or maybe they're just jerks. I don't know. But my question is, if you have a legal license to a Splice sample and the Content ID system says that you don't, and they start giving someone else your Content ID money, does that mean Content ID systems themselves are breaking laws?
Yeah, so, to your point, if someone, through their system, automated or otherwise, so being, let's say, YouTube, starts paying your money to someone else, is that okay? And actually, that's the whole thing that started me reviewing terms of service, because we can be like, well, if it's like not being monitored, is there really liability? The answer is yes, if it's your system. I go on DJ Payne One's website and this kind of thing happens. You're like, well, it's just my automated system. Like, no, you still redirected my money. So the answer is yes. Now, are you really going to sue and spend $50,000 to get a drink? You know what I'm saying? No. But that's why we're really concerned about this, because there isn't a meaningful way for you to enforce, which is the problem with these terms of service. I'm like, hey, just so you know, there's a limitation of liability. You can't sue for more than $100, it says. And you already agreed to it because you had to click that I accept when you signed up. So that's kind of what we're, exposing here. But we went a little deeper with the music distributors, because a few of them, are just quite blatant, and they're like, we can forfeit your royalties if this huge list of things happen, right? There's just claims made against your content. And I've had clients who hire our office because they're like, hey, Chris, I have like $50,000 of royalties. They just took it because there was a claim. And actually, that claim was fake.
Oh, wow. So people are really... And it probably wasn't even a devious, legally savvy person that's screwing people over like this. They file the claim, and next thing you know, $50,000 of someone's money is on hold, and the distributors, they don't care because they're a humongous system, and their terms are their terms, and they don't really want to spend their resources and time addressing an individual's claim over $50,000, which probably is insignificant to them.
Well, and, we get behind the closed doors because, as lawyers, we don't get to talk about this stuff on the internet. We have client confidentiality. But the first time I really addressed this was in regards to TuneCore, because we deal with the distributors across the board. This exact issue all the time. I was locked out of my account. They took my royalties, and they're ignoring me. I keep reaching out, and they won't respond. So then they hire us, and we send a big, scary demand letter. And guess what? We get a response because we have a way to actually get through, and we can sue, and we can do all the things. So anyway, in the TuneCore case, we went through and we're like, whoa, we're looking at your terms, and you're taking this position of we get to just take the royalties. And in fact, in your terms, it says that we can only take them and keep them for ourselves, but we can give them to a third party. Literally, I'm like, I'm going to go and give Crystal all your money because I just thought I wanted to. And so what we did is we just really challenged them. We go pursuant to the law. You can't do this. You're like, it's in my contract. You signed it. And I'm like, I don't care. Under the law, you can't just put this in your contract. So anyway, that's what kind of started this whole mission that I'm on.
Oh, well, more on that soon. I definitely want to talk more about this. Did you follow Maria Schneider's lawsuit against YouTube for blocking access to Content ID systems to individual artists?
No. What was the outcome?
It was dismissed, actually. She attempted to file as a class. Because, with Content ID systems, labels have access to that system. Big companies do, but I don't, and I might have thousands. Well, I have thousands of videos on YouTube. So I put my beats on YouTube. Maybe there's a Splice sample in a few of them. Someone comes along and uses the same Splice sample. They're taking my money. And YouTube allows it, right? Content ID allows that. And so they created a system that infringes on not just my copyright, but also, not even just my copyright, my license to use these Splice sounds, but they're violating Splice's agreement. So I don't know why it got dismissed. It's this is above my pay grade, but why do you think that system just continues to operate? Is it a money thing? Is it a power thing?
Yeah, well, I mean, one thing that just came to mind, because you had said she was trying to get class certification. So a lot of times with these standard terms of service that we all sign, there's not only limitations of liability. So it's like, even if you sue me, you can't sue me for more than $50. And but the class certification is usually something where you waive a right. So you go, by signing this, you waive the right to bring a class action. So sometimes people just lose for that reason. You sign the contract, you just filed, and so now the court's gonna be like, you're dismissed. That may have been what happened, but there are, in some cases, there are carve-outs. All right, there are some laws in some instances, and the best is copyright as an example. So if copyright infringement is happening a whole lot on Spotify or YouTube, that there's what is called safe harbor. So under the Copyright Act, there's safe harbor for these companies that they're not going to get sued for all these different infringements, as long as they have a system in place where you can meaningfully file a claim for copyright infringement. But this is why we have a problem with this, because there's actually a system in place that can result in strikes on your channel, but it can be abused. And that's where we have a big issue, and I did with Splice. But that you can then counter-notify, you can appeal it, right, and fight back. So as long as these companies have this system in place for copyright, they have safe harbor, they don't get sued. Now, for something like, you are facilitating, we'll allege, breach of contract. Are they a proper party? Maybe. But basically, without getting, too micro and not knowing the details of the case, that's how we look at it. Sometimes companies are free from liability because of stuff like that.
You use the term micro instead of ticky-tacky now. I hope you're not replacing one with the other. I Googled it. When I made the video, I'm like, ticky-tacky. because my in a former life I was a linguist, so I like new words, and I googled it, and ticky tacky means cheap and poorly made, and I think, okay, this is a crystalism. So if you ever want to publish, like a tabletop book or something of crystalism, that should go first.
Okay.
So has the Splice situation been resolved? So your videos are still up; they haven't been taken down. Has the strike been removed?
Down. It was taken down, and here's the thing. Obviously the strike is no good. The video being down is no good. But at that point, I had a decision to make, which is my account is at risk. I have a second video already that's up because there's the terms of service, and then there was a new one that I did, right? Because I got the email, we had a phone call, and then I did that live stream. The live stream is the one that they filed the strike against, because in that live stream I go, hey, there's the certified license, and I showed it. And that's what they said that the copyright infringement was about. So the video's down. Besides the fact that that's like a whole lot of time, as I'm sure you know, to put together like multiple stories. It's a lot of time, and I'm a busy lawyer. So the video's down. We're a little upset. I kind of, give them a courtesy, hey, before I file the counter notification through YouTube, just release it. Here's the legal basis why. I understand that you don't like what I said. I understand you don't like that I showed your documents. I understand all these things. Those claims are not copyright infringement. You don't get to abuse the copyright takedown for things that have nothing to do with copyright. And also it's fair use because it was an educational video. And anyway, they, basically came back, told me to take a hike and, just kind of doubled down, and they're like, our proprietary license and all this stuff. And that's when I found, that they had on their own YouTube channel a video showing their license. You know what I'm saying? So I'm like, it's just not flying with me. So I ended up just being like, look, I can get silent here and back down and take everything down because that's what they told me to do. They go, if you don't, we're going to take further action against you. And do I believe them to a degree? Yeah. But am I totally entitled to do what I did and to then do a new video, which is actually what I did. Same day, after my busy work day, I came home, and instead of working on my album, which I really would have preferred to do, I put together a new video and I just addressed it. I'm like, you're not going to silence me. This is what happened. And I go, beyond anything else, yes, I would really love you guys to release the claim. But my mission here was just asking you to update your terms. And P.S., on my call with them before this all happened, the attorneys had said that they were going to update the terms. So I'm like,
okay, so it's like a net positive to the end user. Honestly, it's negative to you because you're knee deep in ticky tacky stuff that really you shouldn't be spending your energy on. But again, you're a lawyer, and you are no stranger to these kinds of litigious conflicts, right? So it's kind of like, why? I don't know. Why even fight this fight for them?
Yeah, well, the biggest concern was just the strike, because at this point there's one, and I don't know. I'm like, if I released another video talking about them, because they had a problem with me even using their name, and they're like, you're violating our trademark. And again, under the law, if you go, I'm going to talk about Top Music Attorney, which is a trademarked brand, you are allowed to talk about Top Music Attorney and use that. It's called nominative fair use. Under the law, if you are referring to Pepsi, it's okay to use their name because there's no way to identify them otherwise when you're talking about them. But again, just trying to be like bullies and all this stuff. And I just go, they could end up getting my channel deleted if they keep going. And they file more strikes and all that because they're just pissed off at what I'm saying. But I'm like, I'm not backing down. So, I put up the video, it sat, it percolated. And then I ended up getting an email from their CEO.
Oh, wow.
And so this went up the chain a little bit, and he basically came in, kept it, short and sweet, and he's like, we're all about the creators. And their team had said this too. They're like, we update our terms, we were going to update our terms, all this stuff, because we're all about the creators and we want transparency and all this good stuff. And he's like, I look forward to us, like, providing true updates to our audience and whatever. We're working on releasing the claim. So I waited, a day and a half, and then the claim to get released off of the channel. And so then I responded to him, and I did the update as of yesterday, which will be releasing very soon.
The claim got released, but the strike didn't.
Yeah, so the strike with the actual claim, they carry together. So the strike and the claim are both now gone. The video is back up.
Oh, okay. So there was a resolution then.
and there was a resolution. You got it. And so that's, you know, where I left this with kind of my big update, which is going through all the stuff that no one else got to see because, you know, the additional emails that I received even before the CEO emailed me and just the rundown and stuff like that. I'm like, I'm not going to pull punches. I'm going to be fair. But there's a lot of stuff in the video that they took down because it was positive overall. And there was a lot of important information that got pulled down. And so my mission was just to update the audience and to be like, hopefully they still make those, you know, terms of service update, because my fight is my thing. It has nothing to do with you guys. Use the platform, you know, do your thing. That's great. But at the end of the day, they need to make those changes, and I hope they do.
Yeah, I mean, they've updated their terms quite a bit over the years, so I don't think there's reason to doubt what they're saying. I thought your videos should have been a net positive for Splice because they set the terms straight, and a lot of the concerns that the end users had, I think, were laid to rest by your videos. Like, yeah, you can use them. This is great. You're safe. This is what you can't do, but it makes sense why you can't, you know, resell a Splice sample as is, that kind of thing. I thought it was a good video. It didn't make me want to stop using Splice.
Yeah, and you did a good reaction to that. So, and in fact, I was like, that's helpful feedback, because I'm like, someone who actually uses the platform is like, you know, looking at this and found this helpful. That's what I do. You know, and then, look, I'll say one thing that was just really positive out of all this is that, you know, the community that we have over on Top Music Attorney, but, like, just generally, like, the music business community, people who use Splice and stuff like that, just understanding the situation, like, a lot of people did kind of, you know, come to our bat just to be like, this isn't okay. You know what I mean? For a company just to be upset about what someone is saying. And I appreciate it. You know, we had some stuff, I think it was in like The Verge, and like Ben Jordan, an artist and also a YouTuber, came out just like to support. And I just go, you know, when we have kind of these difficulties and challenges with these companies, it's not about like, let's burn them down, but just to be like, let's try to get someone in the company who's a decision maker to listen. Because all we're asking for is transparency, and that it would be so amazing if we tried to do stuff because we are in service of music creators that help music creators. So let's do that.
Yeah, and actually, if anyone from Splice is watching this video, number one, thank you. Number two, if you want a legal fight, please fight Content ID.